It is well settled that in seeking summary judgment on the issue of whether the serious injury threshold has been satisfied, the burden is initially on a defendant to establish as a matter of law that the plaintiff did not suffer a serious injury as that term is defined in the insurance law. If the defendant satisfies this obligation, the burden shifts to the plaintiff to come forward with competent medical evidence based upon objective medical findings and diagnostic tests to establish the existence of a serious injury. Here, then, defendants had the burden of submitting evidence that plaintiff did not sustain a medically determined injury which prevented him from performing substantially all of the material acts constituting his usual and customary daily activities during the required time period. Defendant failed to meet that burden. In support of their motion, defendants submitted the report of an orthopedic surgeon. Moeller stated therein that the injuries he found to be causally related to plaintiff's automobile accident included plaintiff's left cervical scapular thoracic strain with intermittent paresthesias, together with left upper extremity and rib and hip contusions. This diagnosis is consistent with the diagnosis of each doctor who examined and treated plaintiff following the accident and whose records were submitted by defendants. Consequently, there has been no showing that plaintiff did not sustain a medically determined injury, and the issue distills to whether this injury prevented him from performing substantially all of the material acts constituting his usual and customary daily activities. On this issue, defendants have submitted no evidence except for the records of 3 physicians who treated plaintiff and who each released him in return for work. The last such report, however, does not release him until July 28, 1997, the 90th day post-accident. Therefore, plaintiff's affidavit concerning his inability to perform at all, or only in some limited way, his usual and customary activities during this period of time was sufficient to raise an issue of fact. Turning to plaintiff's appeal, it is noted that in their brief, plaintiffs expressly abandon any argument that the Supreme Court erred in determining that plaintiff did not suffer a permanent loss of use under the insurance law. In light of the decision of the Court of Appeals, plaintiff's sole contention in their appeal is that the Supreme Court erred in precluding them from introducing proof of a permanent injury at the time of trial. They argue that once it is determined that the no-fault threshold has been satisfied under the 90th day rubric, they will be entitled to recover any damages proximately ensued by the accident. Inasmuch as plaintiff has never alleged that he suffered a permanent fatal loss of use of any nature, plaintiffs apparently fear that Supreme Court has precluded their introduction at trial of evidence of a permanent partial loss of use, thereby preventing them from recovering for such injury. We find such fear to be unfounded, for Supreme Court's determination to dismiss all allegations of a permanent injury was expressly limited to granting partial summary judgment in defendant's favor upon the liability issue and not on the issue of damages.